I'm going to explain the purchase contract, and this is going to be for both buyers and sellers. This is going to take me a while, so sit back, relax, and enjoy. The very first page says attention buyer, and this is actually attention for both. This is a legally binding contract. What a buyer needs to pay extra attention to is this part right here. These are the most important parts of the contract according to the Association of Realtors. The top information, basically lines 1 through 9, is about the property and who's buying or selling the home. Line 10 is the full purchase price. That does not necessarily mean the full price a buyer is going to be paying and a seller is going to receive for the home. That's not exactly what that means. Earnest money. When a seller is in escrow, they have to take the property off the market. If something were to happen and the buyer doesn't close, the extra days on the market can be a difficulty for the seller. So that earnest money that the buyer gives to title and title holds on to it, that is at-risk funds. If there's an inspection period, after the inspection period, if the buyer cancels the contract for a not allowable reason, the seller can keep the earnest money as damages. And there's going to be a section potentially for down payment, which is different from a loan. If they're doing cash, it'll just be the difference between the purchase price and earnest money. If this is a cash sale, there must be proof of funds attached. Proof of funds is where you're getting the money from. Close of escrow. That's the date it's going to close escrow, not the date the seller needs to be gone or the date the seller can move in. It's a little bit more complicated than that, and I'll make sure to talk with you about it separately. Sellers need to be gone before then. And buyers get the keys whenever it closes, Buyers get the keys at some random time in the afternoon, no sooner than after it has recorded with county, and county employees are not required to, process it. They process it as soon as they can, first come, first served basis. There's not a set time that they'll be done other than 5 o'clock. They're not done by 5 o'clock. If it hasn't recorded, it's not closing that day, and the buyer cannot get the keys. The earnest money can be wired funds. It can be a check, personal check. It's completely fine. All funds are in U.S. currency, but you probably already caught that. Possession, you can't get there early and you can't stay late. There's a section where there can be additional addenda incorporated into this contract. Now the next section has to do with the loan. The buyer needs to go through everything. If they're getting a loan, they have to follow all of the rules here, which is responding to the lender as quickly as possible, doing everything that they can, moving this forward. If the buyer loses their job, for example, then they can cancel the contract and get their earnest money back. If the property doesn't appraise, or if it needs an appraisal, if it doesn't appraise, then there will be a negotiation unless it's been waived for another reason. Appraisal cost. Appraisals here in Arizona are always paid by the buyer unless there's some extenuating circumstances. But that's my suggestion, is buyers always pay for that because it gets really complicated if a seller tries to do that. Title and escrow. There's a ton of companies out there, a few of which are partnered with Coldwell Banker. You are not required to use any of those companies. Use them if you want. Sellers oftentimes make a suggestion because they've already got escrow started, somewhere, like kind of a preliminary title report. If so, as a buyer's agent, I encourage them to work with that company because, to be honest, the rules of what title needs to do is all in the contract. So it doesn't vary much. The only difference would be employees, but usually title they're pretty careful with who they hire. I don't anticipate any issues with that. Fixtures and personal properties. The list that I tell you is not complete. There's going to be a lot more to the picture, but what is specifically in the contract matters. When in doubt, ask. For example, dishwashers, stoves, attached microwaves are all considered staying with the property. Items like washer, dryer, refrigerator, those are negotiable. Anything having to do with the windows, curtains, blinds, anything, window treatments on the outside, on the inside, those stay with the property. Again, I'm not going to go over everything. You must know this list because you will be held to the letter of this contract for both buyers and sellers. If there are additional items that the buyer or seller wants to include or exclude, it must be written under the additional existing personal property starting on line 55. If it is not there, you're not getting it, or you're losing it, or whatever the case may be. Financing. The Arizona Association of Realtors pre-qualification form is required as an addenda to the contract if the person is getting, I shouldn't have touched that. Sorry, let me start over. The Arizona Association of Realtors pre-qualification form is required if the buyer is getting a loan. If they're not getting a loan, it's proof of funds. So, there's not a step around that. If it's not on an AAR form, it doesn't count. A letter from a lender absolutely doesn't count. It is not even worth the paper it's printed on. Okay, affidavit of disclosure. Basically, this is for unincorporated areas of the county. It's not applicable very often. Changes during escrow. Hold on, let me start that over. Okay, so changes during escrow. This has to do if a buyer is asking for repairs. If the seller does not disapprove, I'm sorry, let me say that again. The buyer fills out, I'm totally saying this completely wrong. So section 4F, if anything substantive happens to the house, a roof leak, water leak, so anything small, big, if something happens to the house during escrow, they must notify the buyer. Warranties. This is section 5. The house is all houses are sold as is. If a buyer wants something fixed, they must ask for it. Or if something is caught by the appraiser, then the seller must fix it in order for the property to close escrow. A buyer is not allowed to pay for repairs. A seller must pay for the repairs. If there's material latent defects, for example, if a seller hides that there was mold in the bathroom, like what happened at my home, put flooring right on top of a massive mold issue, that is a material latent defect, and the buyer can sue. Let's see here. Section 5C, buyer warranties. There are none. I'm always going to write none there because we don't rely on verbal representations. If there's anything specific, it must be in writing. I should say the only time I'm not going to put none here is if we've had a conversation, about that. But chances are it's going to be none at this point in time. All right, so let's talk about the due diligence section. The inspection period, it automatically defaults to 10 days unless we change it. If it's less than 10 days, that means the buyer is, really wanting the property. This is a great negotiation area because less than 10 days can make your offer more attractive. Sellers prefer the shorter, the better, because the house is going to be off the market and they need the buyer's decision. So buyers, you must do all this research. There's going to be a ton of things here. I'm not going to list them all. But for example, termites, flood hazard, etc. This is your time to discover if there's anything that you don't like about the house or the HOA. It is the buyer's obligation to do the research, the seller's obligation to disclose. So those are actually legally two different things. So they kind of overlap, but not entirely. As part of this due diligence, I want buyers to be aware there will be a buyer advisory, and that's going to be a separate video. And you will have to sign 4 pages, 4 papers in different places saying that you've received it. It's not listed here, but I'm going to make sure to say it as often as possible. Go through the entire buyer advisory, and if there's any questions you have about the property, do your research. This is the only time you're going to have this option. Home warranty plan. It is encouraged, especially by a Coldwell banker, to have a home warranty. It's kind of like a car warranty. You know, if your car breaks, you pay the deductible and then they usually cover the repairs. If you have an absolute choice, if you want it or not, here's that section in section 6K. Walkthroughs, the seller must reasonably accommodate the buyer to view the home. The buyer can't take advantage by constantly seeing the home, but it's not going to be an issue. I'm sure we'll be able to work together if anything comes up. I'm not worried. The foreign investment and real property tax, which is FIRPTA, says that if the seller is not a U.S. citizen, a percentage of the sale must go towards taxes. And it also says that if the buyer, how do I say this? The buyer agrees to perform any reasonable acts to comply with FIRPTA. Basically, title does all of this for you. The buyer doesn't communicate directly with the seller typically. So the buyer is not going to ask for proof of the seller's foreign or U.S. citizen status. Remedies. Well, if anything goes wrong, we're going to look over this. If anything goes wrong, this is the section that we go to. The first part is about the cure period. If there's a potential breach by either side, a cure must be provided, and there's 3 days to remedy the situation. If there's a breach, like I said before, if the buyer breaches the contract, then the seller has the potential to take their earnest for damages. The seller doesn't have to. If the seller thinks there's more damages than whatever the earnest money might be, they can pursue civil litigation. I cannot assist with that. You must speak with a lender. I'm sorry. You must speak with a lawyer to get all that information. If you have a question about legal like this, talk with a lawyer. Alternative dispute resolution, you're probably already familiar with that. So it basically encourages people to not file claims against one another. There are certain exclusions, of course. Attorney's fees and costs are your own. Oh, did I skip? Okay, I totally skipped a page, so you're gonna have to go back. Homeowner's insurance. A seller must provide information up to the last 5 years of ownership of any homeowner's insurance claims. If they own the house for outright, if they own the house outright, they're not required to have homeowner's insurance. At that point, then the seller can just write an email and say, yes, we've had claims, or no, we have. Well, I'm sorry, if you don't have, I said that totally wrong. A seller is required to provide homeowner's insurance information on their, I said that totally wrong. A seller is required to provide homeowner's insurance claims history if they've got homeowners insurance. If you own the house cash outright, then you're not legally required to. But either way, you definitely need to say if there's been any claims or significant damage to the premises. You must disclose that. Section 6F. This has actually come up where sellers might have forgotten if they're on sewer. So make sure that this is correct. If sellers are paying city or private water for sewer, then that is the then that's the sewer system. If a seller's not paying that, it's going to be on septic, and this needs to be entered correctly. It doesn't, and so for section 6G, it doesn't matter if you have a swimming pool or not. Buyers need to sign the swimming pool barrier regulations. Now, 6H is in all caps and bold. The buyer recognizes that myself, as a licensed realtor, there's only so much I can do. It is your job to do all of the research that you need. I can be the source of the source, but not the source. I can give you websites, for example, via the buyer advisory, but I cannot type it in and click enter to pull up a website for you. Now, let's see here. Section 6I. This says the buyer will provide an inspection notice. Basically, we call that the BINSR, the buyer inspection notice and seller response. And it must be received by midnight of that final day. If it's 12:01 a.m., it doesn't count, and the buyer is determined to have accepted the property with no repairs required or being asked for. Buyer disapproval. This is 6J. I'm just going to say all buyers talk with me, tell me your truth, tell me how you feel about the property, your joys, your concerns, whatever it is that might be, and I will help you through this section. If we need to cancel, I will discuss especially what day it is if we're still in inspection. It's one checkoff that says buyer rejected, one signature, and there's no negotiations. The contract is canceled. If it's after that, then we will need to discuss what has happened and see if there's a way we can save the earnest money for the buyer or keep the earnest money if I represent the seller. Now, page 8 is just a whole lot of empty. In this particular example, I wrote none. If there are terms, it will be here. We'll talk about it if there's anything that needs to be written there or if anything comes across and it is written there. All right, buckle up. Page 9 is going to be a long one. Risk of loss. The buyer is risking their earnest money and possibly more if there are damages. Permission. The buyer and seller grant their realtors permission to make this contract public, meaning to put it in MLS that the buyer and seller are now in escrow. We have to follow Arizona law. Time is of the essence, means exactly what it is. Compensation. The buyer buys the house. The seller, out of their proceeds, pay the buyer's and the seller's realtor. And that basically just kind of explains that section. Copies and counterparts, easy. They don't all have to be on one page. All days are calendar unless specifically written otherwise. Calculating time periods. If we need any of this, definitely let me know. The day that the buyer and seller sign the contract and it is exchanged between realtors is day 0. We'll start there. In entire agreement, if a certain paragraph is found to be not valid, the rest of it is. Subsequent offers, they can only be taken as a backup. No one can supersede the buyer once they are in escrow. No one can jump in between those two. Cancellation, unless there's a cancellation, it keeps moving forward. Notices can happen in a variety of different ways. Typically, it's going to be email between the realtors. It isn't when a client emails a realtor, it's when the realtor communicates with the other realtor. And again, release of the brokers. You are holding us harmless and indemnifying brokers for liability, square footage issues, rental rules, etc., etc. Term of acceptance. There is a deadline for when the seller needs to respond to the buyer. If the seller takes longer to respond than this deadline, then an addendum or counteroffer will need to address that. Doesn't mean it's game over, it just means there's an extra little step. And 10 of 10, we're almost there. The buyer broker's information is at the top. The listing agent's information is kind of in the bottom half. And on here it basically says if there's going to be a counteroffer, it's a tiny checkoff box. And if the offer is being completely rejected, a tiny little checkoff box. If there are any questions, absolutely let me know. Again, this is legally binding, so you're going to need to make sure that you're comfortable with these terms, or they need to be modified and then agreed to by both sides. Thanks for watching.